Hi everyone, I'm immigration lawyer John Khosravi. Thank you so much for joining us today. We're doing our regular 5 p.m. Pacific time Q&A, taking your questions about U.S. immigration law, providing general kind of immigration questions, not case-specific stuff, just general kind of stuff that can help you out to better understand what's going on in this amazingly complex world of U.S. immigration. Before we start, I want to remind everybody that there is the Ultimate Marriage Green Card Guide. If you're looking for a marriage or fiance kind of case and you're trying to wrap your head around what's going on, you're going to find this free guide at marriageimmigrationlaw.com. It's the best one you're going to find out there, and it's free too. It breaks down stuff. You're going to get it. Please download it, take a look. You'll be amazed at what is out there, what kind of information that's out there to help you. And if you wanted more information, then we can schedule a consultation after you read the book and discover the strategies and how everything works in this kind of system. Also, to add to that, we do free consultation giveaways, 15-minute free video consultation giveaways for an episode right now. Just that you need to do every 10 minutes. My associate will remind me to read off somebody's name to do it. And how to get your name on the list you read off? Well, you have to like, subscribe, and put a comment like consultation wherever you're watching it. And that way you'll get the attention of my associate Kayla, and she'll announce every 10 minutes one person who's won. Once you've been chosen, you have to take a screenshot of the social media site you're on, so I can see it's really your account from there. And then I want you to then email me with that and let me know. We'll schedule a video consultation to get into your case. So with that, let's get it started. Now, what's going on in the world of education, in the world of immigration? There's a lot of changes happening. Some of them are related to asylum law, some related to immigration court. These are things I don't typically handle myself, so I'm not going to focus on those. But there are major changes that are happening. The Attorney General has changed stuff up. So there's good stuff. On the bad end, the delays are still there. So when it comes to consular processing and work permits. So I can't take questions about timelines and stuff like that. It won't be possible. But the embassies have slowed down dramatically, and they still are for most places. Employment authorization is taking a while, as long as advanced parole. But for the most part, if you're in the United States to do your green card interview, those are somewhat speeding up and becoming normal, especially for marriage type cases. So that is some positive news. What does the priority date have to do with Child Status Protection Act? So let's back it up. And what is CSPA, the Child Status Protection Act? When you're doing a green card case, the person's getting a green card. The people that can be included on a green card many times are their spouse and minor children, a 21-year age cutoff. Well, what happens if the child's over 21? It's not fair, because the case might have been pending for years, and then by the time it's ready to be given the green card, because the case is finally approved, the child may be over 21. So they created this law maybe like 20 years ago that said, when you start the case, usually it's Form I-130 in a family case, and you get a priority date. That's the date that your case started. And then eventually a case gets approved. The I-130 petition does in this example for family-based cases. The time it took, which is a priority date, to get the case started until the date that the case is approved, let's say it took 2 years for the case to be approved, you can subtract that from the age of the child, so that may bring them under 21. So if the child was 12 when you started the case, the I-130 petition, and when they're 14 it's approved, you could deduct those 2 years from the age. It'll still make them 12. Not a big deal. But if they're 19 and a half, 2 years go by, all of a sudden they're 21 and a half, they're past the age, they can still back it up 2 years and go under 21. Now that's a very simplistic way of showing and going through it. There's requirements that you apply in the right amount of time, and you submit certain documents and all this kind of stuff. But that's a very simplistic version of the Child Status Protection Act in a family-based context. So here the question is, what does the priority date have to do with it? Well, the priority date, or really the date that you submit the application, is the date you start for the mathematical calculation and the date that the initial petition is approved for I-130, for example. That timeline can be subtracted from the child's age, and then the case has to, you have to contact the next step in appropriate fashion. That gets more complicated. We're not going to do that here, but I hope that information helped out us. How'd you ask, can I expedite my EAD application as a work permit? I came with the K-1 visa. I got married with my fiance. I have a triplet kids. I need to support them to be eligible to expedite my EAD authorization application. Well, an EAD is a work permit. When you file for adjustment of status, you can submit Form I-765 with the application. And can you expedite it? Well, you can always make a request. Now, if they're going to approve it or not, that's up to them, but you can always make a request. Financial hardship. The Biden administration changed the rules last week to make it a little bit less stringent than what the Trump administration had done, so that's a big positive there. But if you got to do what you got to do. So if you need to make that expedite, you got 3 kids. I understand you, man. It's expensive in the U.S. 3 kids, triplets. It's a lot of work. So do what you can. Contact USCIS. See what you can do to help you out there. Shiva asks, can you tell me about EB3 for other workers? Well, there's not much to tell. There are categories for employment-based green cards that you don't have to have necessarily, a high education or a lot of work experience. An EB3 category is that. There's many subcategories with the EB3, but you need to have an employer that's going to sponsor you and it's going to submit all the paperwork and pay the initial fees, do the recruitment and the I-140 petition, and eventually you can file for adjustment of status or consular processing. That's just a short synopsis for the EB3 visa. Munda asks, fingerprints are done for adjustment of status. How long is it going to take to get a green card? Well, let's get this question a lot. The biometrics of the fingerprints for any case have nothing at all, zero to do with the issuance of the case. So they're separate things. The biometrics is just an automatic thing. It's scheduled. When your green card is going to get approved depends on 50 different factors, including what type of green card it is, what kind of case you individually have, what your background is, how busy the field office is, if the post office loses something. So this is an impossible question to answer. Sam asks, I'm afraid of medical examination because I had TB 20 years ago and was treated and now have negative labs but old x-ray finding. Does that make me inadmissible? So Sam, there's a lot of people across the world who will have false positives on tuberculosis. It's not necessarily an issue. You get tested, they do additional tests to make sure you don't have it, it's not active, and usually it's not a problem. Worse, you get some treatment. So that wouldn't be a reason I'd be worried about. Plus, if you're married to a US citizen, for example, or some places, there's waivers available for it too. I wouldn't be too worried about that. So one thing about if you're getting a green card based on diversity visa lottery, you have to have the case done before the end of September. So if you did your interview and they are, so just do your medical as soon as you can, so you have the results when you can, because you have to have everything done if you're a diversity visa winner. That creates timeline problems. But Sam, thank you for your question. And I'll ask F2A, that's either a spouse or adult or minor child of a green card holder. Adjustment of status, need to maintain non-immigrant status through adjustment of status. Okay, so let me break down what this question means. When you're in the United States and you want to file for adjustment of status green card, and it's based on either being married to a green card holder or being a child of a green card holder, you have to maintain continuous lawful status, not have violations, up until the time that you file Form I-485. Now you can't have other violations, but you need to at least maintain status up until the government accepts your Form I-485, properly filed Form I-485. So let's say you came on a student visa, or you came on a tourist visa. When you file Form I-485 adjustment of status, you have to be in status at the time, but you don't have to maintain that status till the very end. Don't violate in other ways, but you can just stay here in the United States under a period of authorized stay. It's not status, but they let you stay until a decision is made, and you don't need to maintain that status. I know this is confusing. There's some bad information out there. Many immigration lawyers I've talked to don't even know this. I've talked with them that they think you have to maintain the status till the very end. Now, is it wise to maintain your status till adjustment is finally done? Yes, it is, because I've had cases where someone gets married, files for adjustment of status, quits going to school and abandons their student visa, and then 6-7 months into the process gets in a fight with their spouse, wants to get a divorce. Well, if they get divorced, they're out of status, the case is out, and they're going to get deported. So it's always good to keep backup. Why not? But you have to know you could fall out of status after filing and having your adjustment of status case accepted, and then just stay here, don't do other violations until the case is decided, hopefully approved. Thank you for your question, Adam. Paranoid Android Regular asks, my friend is approved for an O1, that's an extraordinary ability visa to come work in the US until June 2024, but because consulates are backlogged, he won't get his stamp until January 2022. Will the USCIS extend validity to compensate for backlog or not? No, they will not, unfortunately. Under extreme situations, they may give a small amount of time extra in some cases, but I would not rely on that. Unfortunately, they're losing out on time. And it just sucks because they went through this, but yeah, they're not going to give automatic extensions. They will have to file an extension request when the O1 time that you have is going to expire. Mohammed asks, hi, I'm a husband of a US citizen who just became a citizen, so when can I apply for citizenship? Should I wait until she is 2 years and 9 months citizen? When you're a green card holder, you can file for U.S. citizenship 5 years after getting a green card. But if you've been married and living with a citizen for 3 years, you can file at that time. If your spouse just became Muhammad as green card spouse just became a citizen, you have to wait for there to be living with them for 3 years and getting citizenship, maybe 2 years, 9 months. I'm not sure how strict that is. But probably if they just became a citizen, by the time the 3-year mark happens, it's probably gonna be 5 years anyway. So I'd have to see the timetables in your case. I can't just say a case-specific guidance like that, but most likely it's not gonna make a difference in your case. You could just file their normal 5-year period because it's already been that long, but I would need to have consultation. 29C, one of our regulars asked, hi, Attorney John, saying hi, good to see you. Any updates on immigrant visa backlogs? Yeah, it's horrible, horrible, horrible backlog. So we talked a little bit about the employment-based cases. Usually the MVC has like, maybe 20 to 50,000 cases backlog, National Visa Center for Consular Processing. Now it's 500,000, 500,000. So expect drastic separation from your spouses, from your loved ones, from your work. Divorces happening, unemployment, people losing their jobs. I hate to be so negative, but this COVID-19 shutdown of the embassies and delays and closure has had catastrophic domino effect on everyone's worldwide lives, and it's terrible. So we'll see how they're gonna fix this, but it's pretty terrible, pretty terrible. Ish asks, if I'm subject to 212E and my country has been removed from the skills list, does that mean I'm no longer subject to the 2-year rule? This is really nuanced. I can't say for certain, but I think you still are. There was actually at a consultation, somebody called about this, so might have been a viewer. This time I have to review more. So just for those who aren't aware, if you're coming to the United States with what's called a J visa, Culture Exchange Program visa, sometimes you may have to go back to your home country and wait 2 years before you can get a green card or specific work visa categories like the H-1B or the L. This is called the J-1 2-year home residency requirement. Now, every country is different and the reason for getting stuck with this requirement is different. But for example, I had a client from Turkey. He came for an internship in architecture to the US for 2 weeks on a J1, went back. He got stuck with a 2-year home residency requirement because on the list that the Department of State has says, for Turkey, if you're studying architecture in the United States, you got to go back for 2 years and spread the knowledge and all that kind of stuff. Well, we got a waiver of that. It was fine. Now, what if you were on the list, your country was on the list of people who get subject to it, but then they changed it? Does it stay with you? I think it does. But I don't want you to go by that because it might be incorrect. So I don't really have a proper answer for you on that. I have to double check the rules. So definitely consult with an immigration attorney. And me to ask, hello sir, I filed my EB2 as a work-based, employment-based I-485. My fiance is still in India and I cannot go to India for getting married because of travel ban. If I get an EAD, can I add my fiance later? Well, yeah, if you get, if you're on an EB2, you may already have an H-1B, and if the visa is still valid, you could travel on that without invalidating the I-485, but that's, talk with your employers. Honestly, if you're going to file adjustment if that's what you had, you should have your own attorney. Don't rely on your employer's attorney. It's a bad idea, but it's additional cost with getting your lawyer, but it's a proper thing to do. But if you do get an advanced parole, you can travel with it. You may be subject to a ban because some of these bans don't make a special exception for advanced parole. I can't remember all the nuances of the India travel ban, but let's say you were able to travel to India and get married before your adjustment happens. You need to quickly file the proper paperwork I-2 for your spouse to get in on it too before your case is approved. I can't remember if the Indian travel ban has an exception for people on advanced parole or not, and I won't be able to check right now. So that's something you should definitely have a lawyer private on me to go over this. There's a lot going on there. Remya asks, thank you John for this love. Is it mandatory to remove the restrictions from the Social Security card after getting the green card? My Social Security says valid to work only on DHS authorization. Well, it's not mandatory, but you'd want to do that. First of all, notify the Social Security office that you are a green card holder so they could take that away and get a new card, because if you find a new job, they're not going to understand what this DHS authorization stuff means, so it's just going to make your life easier. Now, you don't have to. If you're self-employed, who cares? But it just makes your life smoother, and it's better to do it now because maybe in a year or two you're going to deal with an issue that will require that off, and it just saves you time and stress how to deal with it then. Joe asked, what is the entrepreneurship program and what countries qualify? So the entrepreneurship parole program is a very badly designed system, in my opinion, though very many are happy with it, that allows people who are starting a company, a startup, who have investors coming in with a lot of money, who are acclaimed investors, to be able to potentially stay for a couple years to manage a company. I did a very detailed and long podcast on it that was probably over an hour in my other YouTube channel, Immigration Lawyers Toolbox. But I just keep it as that. Very few people qualify for it. So if you're one of them, you'd probably hire an attorney, have the money to hire an attorney instead of asking your nuffets. But it's very few people who fall in this program. It's not something that anyone could just get into. Hi, what's if my wife is working without an EAD after we got married, K-1 visa, during I-485 pending, will the case be denied? So when you're married to a U.S. citizen and you work without authorization, it's forgiven. INA 245C especially designates that, you know, immediate relatives and you did a K-1 case or you're a U.S. citizen for sure. If your spouse did work with authorization, it's fine. The problem would happen is if your spouse got a job somewhere and when she was filling out the paperwork on the form I-9 in particular, she wrote, "I'm a U.S. citizen" to get that job. If you did that, that's really serious, problematic. No way to fix that. There's deportation there. But other than that, no. Peace for All asks, what is the role of an immigration attorney during an asylum interview? I had a friend, he said the lawyer did not talk at all during the interview. Is that common? Well, the immigration attorney is very pivotal, very important, but it depends on the immigration attorney and it depends on the case. For example, first of all, I don't do asylum cases anymore, but if the case was really well prepared, then the lawyer doesn't need to say anything because everything's going to go smooth. But sometimes you might go there and the officer is really comes at you, wants to fight you, wants to question you. So then the attorney has to jump in there and do protection. Sometimes clients are saying some wild stuff, they forget stuff, so it's helping them through the process. So it's a pivotal role to have a good attorney. Now there are attorneys that go there, don't train, don't prep, and don't do a good job and that stuff. So it depends on if you have a good attorney or not, and it depends on the case details. But they're there to kind of, you know, control the psychology, make sure the officers, where they are, they're a witness to things that are going on, taking notes, make sure that the client is psychologically prepared, being there as support. If they see the client's not getting stuff right or forget something, you know, helping out, maybe adding some documents that are needed, maybe, you know, putting the whole story together at the end as closing arguments. There's a lot that could happen, so it is important to have an immigration attorney at these kind of interviews, but it's a personal decision if you want to do that. Thank you everyone else who tuned in. I'm immigration lawyer John Khosravi. If you want to schedule a private consultation, just email me at directlinfo@jqqlaw.com and we'll talk then. Until then, God bless everyone. Be safe. We'll be back next week, 5 p.m. Pacific. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.